Good morning. We're here to put together a little discussion of the evolution of Texas property law in the family law context, and we have a very esteemed group here. I'm not sure how I got included in it, but I'm glad to hang out with these wonderful folks. Let me start on the right down here. We've got Ken Fuller out of Dallas. Ken is the Fuller of Ken's Fuller, one of the great lawyers ever in Texas. Cheryl Wilson from San Antonio, also one of the great lawyers in Texas. Don Royal, everybody knows Don. Don is one of my favorite lawyers, and I think a role model for all of us in many, many respects.
Besides, he can sing.
And he can sing? Well, let's see. There you have it. And Larry Schwartz, who, as far as we know, can't do anything like sing or dance, but is a great, great lawyer out of El Paso, Texas.
And Notary Public.
And Notary Public, Ken says. And on my left, we have Professor Joe McKnight, who, other than writing the Family Code and writing the prenuptial agreement constitutional amendment and all of the statutes that came along for about 20 years after all of that, is a hell of a fella. Still an ongoing professor of Texas matrimonial property at SMU for how many years, Joe? 56?
Quite a number. Since 55.
Since 55. So he knows his stuff. And we're just going to try to track the evolution of Texas property law as it developed in the family law area from the time Joe invented it to the time it was passed on to us, and we've tried not to fumble it away. And so we're going to get started.
Joe, did you invent the Internet also? Did you invent the Internet also?
Only partly.
You and Al Gore?
Just a series of pipes.
With some help.
I think what might be apropos would be for Joe to sort of start with how we came to have our system of family law, just as a brief statement. We can launch from there. Go back to the head right, if you will, Joe.
Well, we can go back a long, long time because of what was here before. That is, I've been writing up some of this stuff about antecedents of present Texas law, especially Hispanic antecedents, of which the community property system was a part. And that was left over, and we liked it, so we took it on. So there's a good deal of Hispanic stuff stirred in there in family code and family law. Quite a lot of a few institutions of various sorts, but community property is the most important one. There's some others, but Texas common law came in with the Constitution, as more or less we have it now. The whole system has been built on that basic foundation of old law, but nobody looks at the old law anymore anyway. The historical stuff is interesting, but kind of beside the point. So that's just where the rock bottom is, but it's just the bottom. That's all.
Well, Joe, what do you think was the main turning point in the development of law, property law in Texas? In the family law context, in your experience, that you've...
Well, in my experience, of course, Ken, it's much like your experience. That is, has been generated by the family law section of the state bar. There's where what the bar initially called the Family Code Project came from.
When was that, Joe, approximately?
Well, that's been going since the since the 60s, 70s. We just been building on it ever since.
And when did we get the first family code? Was that in '62?
Around there,
We got title I first, didn't we?
you got Title One.
And okay, and that had to do mostly with divorce and property rules, and Title II
The sort of
had to do with Sapsers.
The code as we
basic.
knew it sort of took shape between like 67 and 73, isn't that right?
Yes.
Yeah.
I think Title I was passed in '69.
Okay.
Yeah.
You know what's interesting to me, and I was thinking about this when Kathy asked me to be on this panel, was I got out of the Army in 1967, and I was originally admitted to practice in Ohio. And I came here and I took the state bar exam in '66, and so when I got out, I looked at, I took the exam and I had all these areas of law that were substantially different than
Very different.
Ohio, because Ohio was a common law state, not a community property state. And to me, the most illustrative of the evolution was in the retirement area. The Herring versus Blakely in 1965 said Texas could divide community property, that retirement was community property, and from that point forward, we've progressed and evolved to what we have today. And throughout all of this, these changes, I was thinking, gosh, we've lived through all of that, every bit of it. Ken Fuller and Don Royal, our young.
Well, I'm a few years younger, but not that many.
And Brian, these are youngsters, but I mean, we have seen almost every major change in Texas family law from 1965 to the present.
Don't you think the springboard for the real fast development, though, was probably Eggemeyer? It seemed to me to be the seminal case that launched the big change, and that was in 76, 77.
Yeah.
Somewhere in there,
That was a 5-4 decision, if I recall.
Right.
So Eggemeyer basically held that you could not divide separate realty, which I guess that's the first time that it was really enunciated, isn't it, Joe?
I think so.
I mean, just
yes.
laid out black and white, thou shalt not. And I was talking to you last night. I mentioned the Campbell case, which didn't end up in the books, but came along after that and said, but you can divide separate personalty. And then while it was up on motion for rehearing, I was fortunate enough to be involved in a very substantial case and settled it on the basis of that. They settled the case and they dismissed the appeal. So it never got on the books. And I don't know, but after that there was another case, and I don't know, I don't recall which one it was that did enunciate the theory that you could then divide, you could not divide separate personalty either. But I don't recall what it was. And that led to Cameron, right
The
up
Cameron case and our
quasi community property, which says we're going to let you divide it even though it's not truly community.
And that was our good friend Scott Cook
Was
who
it
did
ever?
that. Yeah.
And the interesting thing about that case was it had passed when Scott's case, when Cameron was decided, but the Supreme Court thought it was such a good idea that even though they announced that decision long in June, it seems to me, the effective date wasn't until September the 1st. They said, it's a good idea, we're going to go ahead and do it. And sure enough, from then on, we have been able to divide quasi. community property.
Well, I'm going to cheat a little bit and look at the notes on that.
Well, you're going to correct me now.
Well, I'm just going to give you the years, because
Okay.
Eggemeyer was decided in 1977.
Close.
Yeah.
No penalty.
And then Cameron opinion was in 1982.
Correct.
So for about 5 years there, we knew we couldn't divide the separate real property,
Correct.
and it left in limbo the personal property. And Cameron finally came along and said, no to the personal property as well, which of course in today's world is a pretty big deal, because so many people have investments in items beyond realty that may be separate.
Should we remind people what we're talking about when we talk about quasi community? Just,
Sure.
I know I'm always frustrated when I see these things and they talk about things I'm supposed to know, but I don't. But it's property that would have been community property had it been acquired under those circumstances in Texas, basically.
In other words, acquired in another state.
Yeah, acquired in another state that had they been residents of Texas at the time would have been community property.
Joe, help me here. I recall trying a lawsuit before 1970 in which we had a major recovery because we were able to get a judgment setting aside to our client a substantial amount of separate personal property belonging to the husband, and the lawyer on the other side, who was a good lawyer, was totally blindsided by the idea that that was the law. Now, Eggemeyer aside, isn't it true that there was just a general assumption that, for the most part, separate property could not be divided in divorce cases?
That's
prior to
right. That is, that separate property was sacrosanct in a sense. Community was what was owned together,
Right.
and the separate was individual,
Right.
and that you couldn't step over that line.
Eggemeyer really, Eggemeyer was really not the beginning of that notion that you can't divide separate property.
No, it was there.
Yeah.
It just hadn't been enunciated.
Yeah, it wasn't common knowledge.
No.
There were a lot of lawyers.
I think
that
that
assumed
the interesting part about the quasi-community property to me was when it dawned on me one day. I'd always thought by doing that, my God, they've amended the Constitution, and I didn't hear about it, and they've created another form of community property. But they didn't say we're going to make it community property. All they said is we're going to let you divide it.
You know,
Yeah, I think
there were, I think, if my memory serves me correctly, there were 4 or 5 Court of Appeals cases after Eggemeyer that said, yes, sir, you can divide
That
separate
was
property.
Campbell
yeah.
was a Supreme Court case.
You know, I want to point something out to people who don't know. Don Royal and Ken Fuller and Reba Razor and Don Smith and Louise Raggio, Larry, of course, and Joe was right in the middle of it. All of this family code business came from their hard work and their knowledge about what family law was all about from the Spanish Inquisition up till the late 60s. And I want to tell one story. This is my favorite Joe McKnight story. I was in the legal clinic at SMU, and I told y'all this last night, but in the legal clinic at SMU, we shared a secretary with Joe McKnight, so he would always have to come down into the basement where we were. And that was 73, 74 when I was there, and he was constantly on the phone working the legislature over this family code stuff. And we came in one day, and posted inside the door jamb was a copy of a newspaper article, and it referred to Professor Eugene Smith as the father of the family code. And below it, neatly typewritten, I'm sure by our shared legal secretary, Ms. Johnson, was this comment by Professor McKnight: if Gene Smith is the father of the family code, then I am the creator of the family code, and our relationship is not unlike that of man to God. If you don't believe he had a role in putting this all together, well, he certainly does. So.
Well, I'd like to add a little bit to that because I know that Joe was instrumental and involved at the time of our state constitutional amendment, giving women some rights they did not have previously. For example, a lot of the younger lawyers may not know that women in Texas married women in Texas could not convey their own separate property without joinder of the husband.
Yeah, you had to have joinder.
Yes, even though it was clearly her separate property.
Yeah.
And what year was that amendment in 67?
Around there.
It was somewhere in the late 60s.
I think it's probably around
But the
67.
interesting point, as long as they were single, they could contract
Oh, yes.
and convey
Yeah.
property. But once they married, they had to have joinder.
You know, it's really interesting that you say that. I had the pleasure this last semester of team teaching with Joe in his Texas matrimonial property case, and going back and rereading those cases, and quite honestly, probably reading some of them for the first time. But all those cases back in the early and mid and late 70s, and even into the 80s, they all started talking about our new law and the law now, and it was always in reference to some right that women had. And if you read them with the perspective of looking back almost 40 years, it's really interesting, excuse me, what an enormous societal change it was. And I really have developed this theory now that it was the greatest blow for women's lib and women's rights that I've ever seen, because those opinions, that these innocuous statements at the time, if you look back up now, they just sort of jump out to you, that what a revolutionary idea this was, that a woman who has owned this property maybe for generations of her family all of a sudden had this new right under the new law to be able to convey it on her own, or to contract on her own as a married woman. And I think the family code in that sense, what you did and what y'all did in putting that together, I think changed the face of Texas and a lot of other places for a long, long time. And I know on behalf of myself and my daughter, I appreciate you. And on behalf of Cheryl and myself, I'm glad that y'all delivered the family code to us intact as we emerged into practice, and we never had to learn all this other stuff about the Spanish Inquisition.
And by the way, I did a little work on some of that history a few years ago and had a great deal of assistance from the historians at the Texas Bar Center. And for those interested, they're of course in the archives, some wonderful photographs of Joe McKnight in those days when he was working on the project in the Bar Journal. So for those of you interested, I think it's just a great place to go see history in the making, at least pictorially.
The pictures are still somewhat recognizable.
Oh, you haven't changed it. Yes. Not a bit. Young law professor
That's right.
at SMU.
I think another event that occurred, and maybe that was a little later, up around the latter 70s, 80s, when we got the constitutional amendment to enable us to make real pre- and postnuptial agreements. And I remember you and I and Reba spent some time struggling over the enabling statute after the constitutional amendment was made. And I'll tell you to your face now, I was mistaken in insisting on what I did. You remember what we did with the burden of proof?
Yeah.
And I tried a case after that under the new statute and thought, how could I be so stupid, because I was on the wrong side of position I'd taken, because the judge called me in later, and I wouldn't talk to her. I was still too mad, but she finally, 6 months later, she says, are you calmed down enough to talk to me now? And I said, yeah, I guess so, finally. And she says, well, I heard what your client said, and I believe every word they said, but they didn't meet their burden of proof. We had flipped the burden of proof to the person who is asserting the validity of it to prove that they didn't overreach, really is what it amounted to. So, we made some mistakes along the way, but I think we ended up with a pretty good product. It certainly made the legislative coloring book more interesting.
That's, what was that,
They're
79?
It gets amended every session. So.
That was 79, 80 when all
Yeah,
that happened
about
in
there.
there,
Uh-huh.
and that's another one of those things that just changed the world. That
Flipped
you could, as I think you mentioned it last night, you could basically, as an individual, rewrite the Constitution as it applied to property. Ignore the Constitution and the statutes and all of that, and write your own deal on how your property would be
And fast
divided.
forward to within the last 10 years, we have now passed the what do they call? What is the probate section called? The new statute where you can turn
Oh,
separate
the
into community. Transmutation
Yeah.
statute. For the first time, there is a way of creating community property other than what we were used to before. By agreement now, you can sit down and change character property. And I still think it's full of landmines. I'm waiting for the first lawsuit against the lawyer that didn't advise his rich client that once it's community property, it's going to be divisible on divorce. But
Well, you remember the council meeting we had where their representatives were there, and we raised that point,
Yes.
and their answer was that their clients don't get divorced. They're immune.
but thank God they do. We can all make a living, right?
And ours don't die, so it's a fair trade.
That's right. It sure is. Oh me. Well, I'm astounded when I look back over my shoulder though to see the changes.
Let me ask you about something, Ken, because this is now a paying job, and there was a long time at the beginning where being a family lawyer really wasn't much of a paying job, and we all had to. You got in, if you were on the money side, you were fine, and if you weren't, you were expected just to ride it out to the end and take your chances that somehow, as part of the deal, you'd get paid or you'd get fees awarded and you could collect them, or your client would get enough. And I know you and your partner, Bill Coons, were right at the forefront of changing that. Talk a little about that.
That's an interesting point, and I didn't think you'd ever ask. But it really had two aspects. One, had a legislative or a law aspect, and then it had the practical aspect. And the legislative part of it was settled by passing the statute, and I can't remember, I'm going to say in the mid or early 80s, to allow for the award of interim attorney's fees. And that was a real big leg up that allowed during the lawsuit for you to petition the court for interim attorney's fees and cost, which allowed the court to level the playing field. If you, quite often the person, well not quite often, 99 times out of 100, the person with the bucks also had all the records. So you were getting a double whammy. First of all, they knew all the facts and you didn't, and next they controlled all the money. So the statute came along. But then we had, and still have to, get over the mindset of many judges, though, that not only you've got this power, but by God, use it. Well, family law lawyers, but let's call them what we were divorce lawyers, had an onus attached to it. We were sort of second-class lawyers. They thought that, or the attitude of the public and the bar in general was that, oh, it's just a divorce case. Any lawyer can handle a divorce case. Well, when we got the family code, we started showing them that there was some real meat on those bones, and it took some real lawyering to do it. Well, Bill Coons, bless his heart, I think was the guy with the idea that he took the attitude that, by gosh, family law lawyers are real lawyers. And that guy single-handedly, with me just sort of tagging along and saying me too and holding his coat sometime, he just started a campaign, first of all in Dallas County, and said, for instance, we're going to start taking 2 lawyers to every trial, and we're going to start outworking everybody else, and we're going to start collecting attorney's fees. And he carried the banner, and he literally single-handedly brought us out of the closet and into the courtroom as real lawyers and got the judges in Dallas County to awarding interim attorney's fees and also upon final hearing to award, and I'm talking about substantial attorney's fees. And I always remember we were in Linda Thomas's court one day, and we were going to have to go to Portland, Oregon, it seems like, to take depositions. And that was before I went with Bill, in fact. I was ad litem in that case. And before we left, Bill told the court, he says, I want to travel first class in this case. And it was from a very prominent family and had plenty of money. He said, I'll guarantee you, Judge, that the respondent, when he goes up there, he's going to go first class. And he said, by God, we're first class lawyers, and if we want to travel first class. And Linda Thomas literally entered an order that the ad litem and the petitioner's attorneys would go first class. And he just carried that theme all the way through. Then we got it going in Dallas County. We started spreading the word among the Family Law Council first and others. And Bill literally started going around the state testifying. I remember he came to San Antonio,
with all of the
testified a time or two. I remember he went over to East Texas a time or two, and he came back sort of beat down over there. They didn't believe in paying lawyers anything over there. They didn't care whether you're a family law lawyer or anything else. But it turned the tide, and it got the word out to the other lawyers, and they started doing it, and it's a whole new world. Those of you who practice law before the statute changed and before, I call it the Bill Coon offensive on behalf of lawyers, you just don't know. I remember you'd go in there and ask for $50 an hour or $100 an hour. They'd look at you like you're crazy. And now then, heck, I see young lawyers get up there right out of law school, asking for $150 an hour, but even allowing for inflation. It's amazing, and you see these fees of $500, $600 an hour, and the lawyers are earning it, by George. They're out there doing a job. So I think it was the greatest gift to family law next to the family code that I know of in my 50 years of practicing law. And
well, let me just comment.
This guy.
Let me just comment on your modesty about holding Bill's code and all of that, because I know that nobody worked the legislature better than you did. And you were the legislative point guy for most of family law back in the early and mid 80s and when all of this stuff was going on. So thank you for your contribution.
I want to add to that, too, because I don't think Bill Coons and Ken Fuller have been given enough credit. For those of us who were around then, many don't know that this man spent an entire legislative session in Austin, Texas. He lives in Dallas, had a family in Dallas. His law partner kept the machine going up in the law firm and made it possible for this man, without some legislative aid or a lobbyist or anything else, this man went to those legislators and got that done for us and was really the model for what the family law section has done today in getting itself organized through the foundation and other means to have a voice. And he was our lone voice and got it done.
Yep.
But thanks to Bill Coons and Ken Fuller for making that happen.
The message is you got to give a damn, and you got to be involved. And to propagandize a little bit, our message to all the people who are going to see this is get involved with your association, get involved with your foundation, because you'll help yourself, but you'll help the profession. And if you make the profession go up, you're going up. So
I think that I remember when you were coming down here every week. And
I like
and
Oscar.
Well, he had an apartment here. He didn't come. He was here that much.
and
And you know what it was? It was the couch in TTLA's office.
and since that time, this guy on my left here has
Absolutely.
almost
Absolutely.
given up his practice from time to time to lobby for us, if that's a proper word.
Well, these changes don't happen accidentally.
I mean, and I think that carrying our water to the legislature and the family code that Joe was so prominent in creating, it would have never gotten passed had you guys not come down here and you had to sell it to the legislature. I mean, some of those people over there, they couldn't have cared less, and they didn't have any interest in it. And I appreciate it.
They
I
keep
think
late office hours, too.
And I started to make the connection in those old clinic days, watching Professor McKnight on the phone all the time. And all of us have been there and involved in the council and the foundation and this and that. And we know it's a big group effort, not just a group effort, but it's a big effort. But we've been able to see generation to generation how it affects you when you're paying attention to it. And we've also been able to see how it affects you when you're not paying attention to
Economic
it.
contribution comes to
Anybody
mind.
recognize, everybody remember that?
You're going to get me started.
Yeah, no, this isn't about that. But that was a matter of
tell you
not
what,
keeping up.
the evolution of property.
Yeah.
Well, I call that the sinking phase.
Yes.
Yeah.
Economic contribution had to be the worst piece of family law legislation that I was exposed to in the whole time I worked the legislature and practiced law. And it's still puzzling to me how it ever occurred, because it was really a piece of case-specific legislation where a certain legislature who shall go unnamed, we all know who is, was involved in a case and got a result he didn't like, so he went down to change the law to remedy that specific case, and it was a total disaster. The judges hated it. Every lawyer I ever talked to, except him and a couple of our other brethren who were
Harry and Sam.
instrumental. I won't name them.
Jack?
I won't name them. But except other than
But Larry
those two,
will.
every
I
lawyer
will.
I've talked to, they were universally opposed to it.
I've
And
met
it was the most poorly drafted. Even if you agreed with the concept, it was a total disaster.
I've met two lawyers who rued that it went away. They regretted that. One who clearly didn't understand it, and the other one who was going through a divorce and thought he would have gotten a much better deal if it was still in place. But Joe, I have a picture of Joe and I, and we're holding up the T-shirt that came out after that with the economic contribution in the circle with the slash across it. So it was, yeah, that was a matter of we had people in there telling the world that they represented us, and people coming back, the same people coming back to us and telling us they represented us, and telling the other side, this is what the family law section wants, and then coming to us and saying, well, it's a done deal, you don't have any choice.
It was done by stealth and deception.
Yeah, and
It
we
came in below the radar, and before we knew it, it was
we
the
accepted
law.
it. So the message about all that is, you know what? Have a legislative program that everybody's engaged in and everybody's active, and then you know that you're going to control, to the extent you can in the legislature, you're going to control your own destiny in terms of what's coming at you and what you're
The point that
submitting.
needs to be made about, on the legislative side, is there's probably more danger from things you need to kill than what you need to do to change the law, has been my experience.
Yeah.
A lot of it ain't broke. A lot of it can be cured with good lawyering. But if our consuming public, to wit, in this case, the lawyers, aren't willing to devote the time and money to it, they're going to suffer the consequences. So
There's a lot of people out there with some odd ideas that are trying to throw
Absolutely.
legislation at us all the time. And I'm going to tell you all, you really haven't lived until you've eaten pizza in the hallway in the basement of the legislature at 1 o'clock in the morning, waiting your turn to testify in front of some committee.
In dirty underwear. Because you've been there 3 days.
That's a personal thing.
That's enough.
Well, I think maybe we ought to get off the political side and talk some more about some of the changes that have been made. I think that's what these folks are probably interested in. And Larry, why don't you tell us some of your ERISA history and like the Former Spouses Act and things like that.
Well, you know,
and how it came about.
When I got out of the Army, Herring versus Blakely had already established that vested retirement, private retirement plans were divisible as community property. But, you know, there was this big...
How about the unvested, though, like the military?
Well...
How we got there?
In 1965, we didn't have any guidance on that. And, you know, then came along the Busby case where...
that was
Texas
that was a naval retirement guy, wasn't it?
I think so.
Huh?
I don't remember what branch he was in, but... and then... in the Searly case, you know, the contingent, the unearned interest, unvested retirement was divisible, became divisible based on years of service, and I think it was a guy who was in the service who had been there for 19 years, and he decided to. Or he had been married 19 years while he'd been in the service, and he was not retired, and he decided to retire a year later after he got his divorce, and then the court said, well,
if, as, and when. That was the
exactly
first. If, as, and when we got.
And then the on the cases that had already been decided, you know, we had the partition cases. And but you know, the blow came when McCarty, the Supreme Court of the United States, came down and said, well, you know, you guys can't really divide that. That's a federal benefit, and it would do terrible damage to the intent of Congress if you divided it. And fortunately, and for the first time in my experience, somebody jumped on it. It was a congresswoman from Colorado, and she...
That was most startling thing I'd ever seen happen legislatively on the federal level in the area of family law.
Right.
In a matter of 6 months, she got on that thing and got the law changed.
Got the law changed. And, you know, it was interesting that the statute said, well, you can start dividing property as of 1 day before the McCarty decision. Those that were caught in the gap had to rely on different methods, maybe partitions and things of that nature after the statute, and division of the asset after the Former Spouses Protection Act. But that turned military retirement on its ear. I mean, that was...
There was a 180-degree turn. Yeah.
It was a hue and cry from all over on how unfair that was. But I have some old newsletters and things from some of the military retiree organizations about what they needed to do and how they needed to respond, and it was a concerted effort to try to keep the law as McCarty said it was. But I think once we evolved through that and the Former Spouses Protection Act was enacted, things seemed to calm down, although there are problems all the time in military cases. The drafting, to me, is more of an issue than the law and the intent of the law.
Well, it's been my experience in the area of retirement property that we're reactive. Somebody has to get hurt, and then we get the law change. That's how it came up with COBRA.
Right.
COBRA being the continued health care. And you and I were talking about that last night, about when they first passed the state, I'm going to call it state COBRA law. The problem was, for instance, that said you'll do that. You'll provide continued health care for these people for 3 years. They didn't say anything about the premium. Tell them what happened.
Oh man, the premiums just went through the ceiling.
About triple, wasn't it?
Yeah.
Well, Larry, excuse me, but it occurred to me that for this audience, there's probably a substantial percentage of this audience that doesn't know how absurd the treatment of insurance proceeds and things of that nature was before then. So maybe we ought to back up and explain that.
That's a good idea.
That prior to that, for example, if you were the spouse of an employee who was covered by a plan, and you got divorced, the spouse just simply didn't have any medical insurance and was not eligible. And if they had some sort of medical issue that would create them, make them uninsurable, they were just out.
Well, I had several of those. They were tragedies.
Yeah, I mean that right now that seems like such a bizarre thing. It could not possibly have been the law, but it was the law.
It was the law, and I mean, I have a case right now that the gentleman he's got 26 years in, and his wife, he's been married to his wife for 19, and he chose to retire 1 year shy of her being able to get that, what they call the 20-20-20,
the military,
which is the military medical insurance benefit. That's devastating.
And commissary and all that.
Yeah, all of that stuff. And also, we have to remember, ERISA came along. Then we started having qualified domestic relations orders.
Voila.
And, in the beginning, all of the administrators, it seemed like, just gave you the hardest time to get an order qualified. Now you send it in there, and most of them are they'll get back to you.
To give you an example, I had one with Barclays Bank. And about 3 days prior to the 18 months that they have to approve or disapprove, I got disapproval on one. But they work the system. They're going to back the employee. They're partisan.
Well, you had 30 days of plenary power, and they had 18 months to decide. And like you say, initially they were all violently opposed to being drawn into this at all, so they were resistant, and they took their time, and they'd turn you down at the last. I mean, it was a tricky practice, and it was a hard practice, and it was a real hard practice to explain to your clients. It's how, it was always your fault. So it was a very unpleasant
and your
period.
Malpractice carrier.
Exactly.
Well, before, I think maybe some of the younger audience members would like to know what we did before we had ERISA. And we were able to, we had the legal authority to divide up these retirement benefits between divorcing people. But what we had to do was draw an order making the employee spouse the constructive trustee for each and every payment received by him or her for the benefit of the now former spouse. This was a nightmare where divorced people had to have that kind of continuing arrangement made without a third party like the retirement plan being in the middle of it. So when we got ERISA and we got the
direct pay
through the military cases, and the same thing with the civil service people, that was a pretty big change and a helpful one. So it wasn't all golden in those old golden years we kept talking about.
Not only that, but while we're talking about the ERISA thing, before ERISA, if a judge signed an order simply dividing a pension, the IRS took the position that was a present award, and they would present value that future stream of income and hit the recipient with an ordinary income tax on a lump sum, which was, I mean, until we had a
disaster.
Oh,
Horrible.
But I think we've come through most of that. I mean, we still have. I still have problems with some of those. But I think that the improvement,
some scary files in my
you know, it's just been tremendous, and it's you know, the pathway is out there, and for the most part, if you follow the rules and the regs and so forth, you'll usually be able to get down to the end without too much of a problem.
Look how some of our methods of evaluation have changed.
Oh, wow.
See?
Yeah.
Now there's a book there somewhere, but you might, why don't you point up a couple of those, like what we do with our defined benefit plans now versus what we used to, and how some of those things came about.
Well, you know, I've got one going right now. I just hired an expert to present value the plan, and we're sitting over there.
Well, yeah, but you now trace within the plan.
Exactly.
See, it used to be opening balance, closing balance, and that's it. But that's legislative changes. But that came from the council, didn't it? Yeah, that was one of our things, and that's what you got to be involved. You got to give a damn about this stuff to keep from getting blindsided, and you'll end up with another economic contribution.
Oh.
You know, I've always said
Please no.
that I'm no mental giant, but I learned more from being on the Family Law Council, coming to the seminars, and working on the Family Law Practice Manual.
Oh, absolutely.
I mean, to sit through some of those Scott Cook, John Nichols fistfights over what the law is really gave me a pretty good education. You know, I was at a meeting one time. You were at the same meeting, I remember, and maybe you were there too, Don, when Reba Razor and Don Smith, and I can't remember the third person, got into at a council meeting. They were arguing over some kind of legal point, and I'm sitting there thinking, golly, I didn't even know that was a problem. And they were, I mean, going at it, tooth and toenail, and Sam Emerson, after about 30 minutes of them getting after each other, spoke up with the most clear answer to the problem. Simple.
It helps if you're smart.
Yeah.
And Sam was smart.
Sam was
he
brilliant.
got it.
And I mean, and he was practical.
Yeah.
And I just sat there, and it really took my breath away because it was so enlightening. But it sure sent a message how much I didn't know.
Well, I think a message for our audience is, too, that probably 50 years from now, our successors, I think, are going to be telling a similar story. It's just that we have no appreciation of the problems that are going to come up in the future. The things that just startle me are the changes in the law that are resulting from technology, things like that. I'm sure that property law is going to undergo a real metamorphosis, don't you think, Joe? In the future, is going to have to be
happening.
Legislation and changes in the law to accommodate things now. I mean, you know, electronic filing and things like that all sounds good, but then when you get down and start meeting the everyday problems of it, there's some real pitfalls in there that I think we're going to see a change. I hope to see some laws enacted to take care of those, and I would like to see someone undertake to simplify the damn discovery rules, which I think are so ridiculous. They've changed the nature of litigation to the point that I can't even comprehend it anymore. If in in the 1960s. Can you imagine if someone sent you interrogatories or a request for admissions in a divorce case? You know what you do?
You Xerox them and send them
Send them back.
back.
That's what
Exactly.
Change the name and date and send them back.
That's right.
That's the way the game was played.
And there weren't any rules to make anybody answer any of
That's
them.
right.
So.
And then nobody answered them. But
It's interesting with the technology what an explosion that's been, and intellectual property as an asset has just gone nuts. The .com community has changed the face of stock options and employee benefits more so than anything else, because they've got this ongoing competition for the big brains to move here to there, and I just think that's an enormous thing. We struggle every time we send out discovery with how to fashion the right request for production to get all the stuff, because first it was MySpace, well now it was Facebook, and that's the easy part, but the technology moves so fast that you almost by definition have left something out of the request if you just use the request you used from the last case. And it's a tricky business with that, and I think Ken's right. When Gene Roddenberry died, and several years thereafter, the Star Trek guy, and he had gotten his divorce back, I think, prior to Star Trek II on TV, the second generation. After he had died, and when they were well into Star Trek third generation or whatever they called it, his second wife and his widow were in litigation over the rights to all of that on the theory that it was an ongoing creation that had been community in the first place, as opposed to a new venture that had come up during her marriage to him. Well, I don't know what the answer. Tom Clancy was going to change the name of Jack what's-his-name in his books because that was in litigation, and the Blue Dog guy was that a community
he solved
asset?
that by getting a co-author.
Yeah, exactly, and then started painting chihuahuas on the painting. But all of that stuff is changing so fast, even on a weekly basis, and I think you're exactly right. It's not going to look the same, and everybody has to be paying attention to that on an ongoing basis. We can't use the forms. The form book almost can't come out fast enough anymore, although that's obviously the best place to start. But you've got to be thinking creatively to get these property issues properly before the court.
It's a real disadvantage for those of us who are technologically challenged, and
hire people who aren't. That's
well, hire a younger lawyer. I've noticed in our firm, Crystal Thompson is almost a 10-year lawyer now, but I still kind of think of her as the youngster around our office. But she is so helpful to us older ones. I don't know how to use the right technical words when I'm asking for something in a request for production, for example. In fact, I went to her just 2 days ago. What words do I use about what somebody has on their Facebook page? I don't know the right words to describe what I want them to produce to me.
See, I'm deeply disturbed, though, about the whole field of discovery. It's gotten so out of hand. It's complicated litigation. It's driven the cost of it up. Supreme Court sits there and hacks on us about the cost of litigation, and people can't afford to litigate. And then they keep passing these damn rules that make it more complicated every time you turn around. And we've got to get people involved to fight the problem, because I think it's going to destroy the advocacy
well, and it makes
approach to lawyering, because they want you to show everything. It just
Well, Ken, if the nature of property is changing, and if we're dealing with technological change at an ever-increasing rate, I think it's a bigger problem than just difficulties with the rules of discovery. We've got and this is a reason why, incidentally, it seems to me, we need to get more of the younger, tech-savvy lawyers involved in what the family law section does and in its leadership, because
Absolutely.
they're speaking a language that we don't speak.
Hey, guy, we're over the hill.
Yeah.
No, literally.
Hey.
But no, we need
Some of
help.
us still trying to make a living.
That's right. That's right. Well, we know you got to live on what you kill when you're a lawyer, and when you're a family law lawyer, that's even more pronounced. But no, I'm just saying that one of the areas that we need to be concerned with, though, is in the discovery process. I think that it's just been overcomplicated. I think it's resulted in backlogs. You can't get to trial. It's driven the cost up. It's got the consuming public up in arms. They can't understand why you have to do it all, and they threw out the baby with the bathwater when they, in my opinion, thought that discovery was going to simplify litigation. It's complicated, in my opinion.
Well, and I think the rules of evidence have done that in some respects too. I don't think any of us here went to law school when we had rules of evidence. We learned evidence under common law theories. We didn't adopt.
No, there were no written rules.
We
of
had
evidence.
no rules of evidence, at least in Texas, until what, the 80s?
80s.
Well, now we see all kinds of hearsay objections, for example, on bank records.
Hell, look at the
know,
rules. It's 4 pages.
Yeah, and the difficulty sometimes in admitting a simple bank record or a credit card statement, when you have to go have it authenticated by the bank, and the cost of that, not only the cost of literally having it done, but the cost of getting it done.
Let me interrupt you there. On another example of it, with all the bank mergers and acquisitions.
Oh, yeah.
Now, just think for a minute. What are the complications? We had our rules, and now then, where you had 75 banks before you got 2 or 3 big ones, have you tried to go to them and find out something about the records from the banks they've acquired? Good luck.
Well, with the law saying, well, we only have to keep the
Oh, yeah.
records for 5 years or something like that.
Hey, Bubba, and you got to pay for the search.
Right.
Who
Oh,
can
yeah.
do that?
Well, in El Paso, it's even tougher than in some of the other places because,
Is that in Texas?
well, it's very close not
Parts
to
of it
being.
are.
It's, it may spill over.
But it's just an impossible.
Let me jump
very
on my
difficult.
soapbox just a minute about this whole discovery thing, because I've done this before and I'll keep it short. But one of the problems we have in discovery is, if there are any judges out there who see this, we go down on a motion for sanctions or a motion to compel or whatever it is in our cases, and almost invariably any sanction, whether it's fees or whatever it is reserved until time of trial, knowing full well that in 95% of the cases there will be no time of trial, which means that for the remainder of the case, you function without having been able to get that information. You settle the case without having been able to get it. And I think judges are there to call balls and strikes. None of us would be at the courthouse if we had been able to resolve it on our own. So when we get there, all we need is an answer. Even if it's one we don't like, it's better than where we were.
Amen.
And secondly, to make the judgment as to whether somebody is operating in good faith or not. Now, you may not know for sure whether somebody withheld something or not, but what judges are supposed to be able to do is look at people and ascertain their credibility and their veracity and then their sincerity.
And make a call.
And make a call. And even if it's wrong, if you tell somebody there is a repercussion to their behavior, then they will modify their behavior and something will have changed in the case to help move it along. So stop this, reserve it till time of trial, because otherwise, like Ken says and everybody else agrees with, discovery has become this horrible morass. And we just sink deeper and deeper in the bog, and we spend more of our clients' money and more of our time accomplishing less, fighting about that, never moving the case forward on the merits. And we just need somebody to make, come on, judges, you can do it.
I bet you 40 to 50% of the cost of representing a person in a divorce case is attributable to discovery. And it's used as a weapon more than for a tool to try to find out what the truth is. And it's just a big cat and mouse game. And I'm not smart enough to rewrite it, but I am smart enough to know when it ain't working, and it's broke.
All right, Cheryl, you want to talk a little about spousal support and get us
Well,
moving?
sure. You know, I started out in 1973, and I know that was a little bit after the rest of you, but not that much after the rest.
It's a little before me, isn't it?
Is that right?
75, yeah.
Okay. Well, yeah, we didn't have any alimony. That was not good. Not good at the time. No judge could do anything that smelled like, walked like, talked like alimony, at least in a division of property. And it was, we used contractual alimony lots of times to settle cases, but that was on a final hearing. And so, what year did we first get our spousal support, what we now call maintenance? Was that around late 80s, early 90s?
Well, you mean,
We was in
better word, the alimony statute?
That one.
That one.
Well, the temporary alimony, not the...
we had temporary forever.
1995.
Yeah. Oh, well, I'm not talking about the temporary. I'm talking about the
alimony. We started talking about it in the late 80s.
1995.
95 was the
Can you
first
believe
year
it?
that it was a legislative enactment.
Mm-hmm.
It's pretty limited. There was a lot of backlash,
Conditions.
a lot of conditions. My recollection is it was really passed as part of that Welfare Reform Act. I believe it was Symphonia Thompson, wasn't
the
it?
first
Yeah,
time it came up, it didn't pass.
We had a bill.
And-
You were right about the late 80s because we had a bill like every session.
And it was
Couldn't
so
get it, couldn't
unpopular
get it,
that
couldn't get it.
on first reading, I was not there, but I understand that on first reading, they did a Khrushchev, that they took their shoes off and started beating on the desk. And like I said, now I didn't see that, but I understand that the first time it was introduced, that the legislators, a group of them, took their shoes off and
That's the
started
first time I've heard that story.
You hadn't heard that? Okay.
There was
That one either.
that bill used to be referred to as the one-armed, one-legged blind woman from Clute bill.
Yeah, there you go.
Because she was the only one who could possibly qualify.
It was Reba that gave it that name. That's right.
Well, and and frankly, there were a lot of women's groups who found it abhorrent that Texas did not provide any kind of benefit or help to a woman who had been married, sometimes for many years, a stay-at-home wife or mother, and maybe had accumulated very little in assets to be divided by the court. You know, the theory, I guess, was, well, gee, you're going to get a nice big piece of the pie when you get divorced, but if there was no pie, it was very difficult.
Pie was a problem.
Very difficult for those women, typically women. And so...
Well, another argument against it also was the fact that our statute provides for a disproportionate
Same thing.
thing. But again, if there's nothing to divide, it's still destitute.
It was a very, very difficult thing, and still is in many respects, when the pie is not very big. And so I guess in our first version of the maintenance statute, we had, what was it, 3 years max?
Yeah.
Something like
Something like
that.
that.
3 years.
3 years max, and there were all those hoops to jump through about qualifying to receive and all of those things. And jump forward to this last session, and it can go for how many years now?
It's
10.
10 years, yeah.
And with a
You know, you got
Yeah, what the cap's up to,
30-year
but-
marriage. I
right,
mean,
and with fairly decent amounts, livable amounts anyway.
Still
So
maxing out at $5,000 a month.
right, but it's certainly better than what we had before. I can remember going to lawyer seminars where we had lawyers from other states, and they just could not believe that
Yeah.
we would have divorce cases without some ability to provide for that. But that was our law for all of those years until the little bit we got was in 95. So I think that in many respects is a good step forward. It would obviously be better if the need weren't there, but there are many cases where it is a need. And from my point of view, in practicing for 39 years now, it's so interesting to see how few women there are who don't have some ability to earn a living.
It's true, and if the test is strictly applied, there would be very few cases where it would be granted. I'll never forget the shock that I underwent the first time I had a judge order a wife to pay the husband. It was a very interesting case. He'd had a RICO forfeiture where he'd had to forfeit all his property on a RICO charge and serve time. And then when he did finally get out of prison, he came back, and we ended up trying a divorce case. After that, and of course, his half the community had already been confiscated by the Fed, and so my client was ordered to pay spousal support interim, and a good healthy sum. There's a lot of money involved, but what had me worried about is what the judge was going to do at the end with the other half that was left, and so we took the stance that that was separate property. Then it couldn't be divided. And the judge bought it, fortunately, and it never went up on appeal. And I don't know if it would have stood up or not.
How did it get to be separate property?
Well, because
Ken said it was.
It was an involuntary
I'm going to give you
partition.
what.
How do you
I'm
win
gonna
a
give you what we told
hand with ace
What we
high?
told the judge is that when they divided it in half, the Fed took his half. All that was left was our half. So they partitioned it. No, we took the position that it was a postmarital
Involuntary
Yeah,
partition.
partition. Yeah.
Professor, if he'd have
Yeah.
given that answer in response to a question on your
hell.
exam, what grade would he have gotten?
Well, I would have put a big question mark in the margin.
Well, you got to say something. That's like I was arguing a similar thing to that up in McKinney one time, and a lawyer pulled an advanced course article I'd written on the subject and says that's not what he said in his article at the advanced course 6 months ago, and I told him, and the judge says, what's your reply? And I said, well, I've talked to Reba since then. I've learned a lot. I don't think that's a law now, Judge.
That's not. I changed my mind. My mind has been changed for me. Is
There
that
you
the
are.
answer?
There you go. But you're right. That was a real landmark, even though it was a very restrictive statute. But I remember when we passed it, and I remember everybody saying it's not enough, it's not enough. And the consensus was, let's get our nose under the tent, and
That's exactly right.
we'll go later on. And sure enough, it's worked out that way. It was a pretty valid plan to go by. So that has been a big change.
That is a huge change. But like I say, I'm not seeing as many cases where the need is so great as it was in years past. And
True.
that's because women are
making
working
more
and
they're-
making more money.
Yeah.
And, there is a case sometimes where the husband needs a little alimony.
It sure is, honey.
And contractual alimony continues to be a big part of most cases.
Oh, yeah.
You know, it's
Particularly in the larger
always been there.
larger
And,
cases.
yeah, but you're exactly right. Women are not staying at home and
No.
doing nothing for 20,
You know
30
what really
years at a
changed
time.
family law in Texas, though? specialization.
Yeah.
I think specialization was the real launch point for lawyers, compensation-wise, and also for the development of family law, because people started doing family law exclusively and paying more attention to it and getting organized. And Don, you've been there from the start, partner.
Oh.
Why don't you talk about the test? And
Well,
some
before
of
I get to that, let me just tell you, when I first heard about family law being an area of specialization was 1976, sometime early in 76.
70,
wait now.
75.
No,
75 was the
I've
first
been
test.
hearing you all say that, but the first specialization exam was in 1976, not in
No,
75.
I was board certified in 1975. I have the certificate that says it.
Yes.
It may be a forgery. But okay, well, I will defer to my elder colleague here. So
I can't believe that
it's
at
been
least
so
one
long
of you-
ago. Maybe all this is a year off. But anyway, the first I ever heard of it was at a council meeting in Dallas. Tom Purdom was the chairman at the time, and he was allowing as how the Board of Legal Specialization had designated family law as one of the areas and had not consulted with or the Family Law Council in any way with respect to setting up the standards and so on and so forth. And we were in a little bit of a huff. So I was delegated the job of going to San Antonio and meet with the Board of Legal Specialization to, on the one hand, voice our concerns and to offer to work with them.
What were they doing in San Antonio?
Board of Legal Specialization was in San Antonio meeing.
They were having a meeting.
They were having a meeting, and I was delegated to do that. Now, those were in my biker days. I was. Some of you remember there was a period of time there where I would, anywhere I could go on a motorcycle, that's what I did.
That was your midlife crisis.
My midlife crisis, yeah. Anyway, so I was to meet on a Monday morning with the Board of Legal Specialization, and so on Sunday I rode over to San Antonio on my motorcycle with my nice polyester, y'all remember those, my nice polyester kind of saddle-colored suit packed in a suitcase with my nice shoes and so on. Of course, I went over there in my leathers and boots and, you know, the whole bit. And my baby daughter, Karen, bless her heart, had shined my shoes and before we packed them, and apparently she had used about 1 can of polish per shoe. Because when I got to San Antonio to the hotel there, is it the Hilton that's right down there on the river? To the hotel there, and I unpacked my suitcase on Sunday afternoon, I discovered that my suit was covered head to toe with shoe polish. Sunday afternoon, and you can forget trying to find a cleaner on Sunday afternoon. And of course, when I called the desk at the hotel, they said, "Well, you got to be kidding. We'll be glad to have that for you by Tuesday morning." And so I got on the phone and tried to call around to see if there was any place open that I could buy a suit, and I couldn't find anything. So didn't know what I was going to do. And you can think I'm making this up, but it's a true story. What I did was I put the suit on and got a bar of soap and my hairbrush, and I got in the shower. And I rubbed the soap all over the suit and brushed it with the hairbrush and washed the shoe polish out of it. Took it, blocked the pants, filled them up with. I pulled a sheet off the bed and put them in the pants, and took the coat and hung it up by a pair of vice grip pliers. I had a bag of tools I always had on my motorcycle, and hung it up so that the air conditioning would blow from the ceiling on it, and sat there in my underwear the entire Sunday evening at night so that I would have clothes to wear the next morning. And it was an amazing thing, but the next morning that suit looked like it had just come from the cleaners. So I was able to make a good impression, I hope, with the Board of Legal Specialization.
And that's how the Don Royal cleaners chain got started.
Yeah.
That is the best polyester clothing story I've ever heard in my life.
I'm telling you, I had a light blue one and a kind of a tan colored one in, but anyway, that I was very impressed by the polyester suit. But that was the first exposure I had to the family law, to the Board of Legal Specialization, and they were about to administer this test. And I met with them, and they were very nice, and we got along fine, and we offered to assist them in the future, and so on and so forth. And so they asked me while I was there if I'd be interested in seeing the test. And I said, yeah, I'd love to. And in those days, security was very high. They literally took me into a room and locked me in with the test while I looked at it. And when we got through, they came back and said, well, what do you think? And I said, I think this test is too hard. Nobody practicing law today will be able to pass this test. And so that's how I got involved in it. They said, well, would you help us write a test that lawyers could pass? And it turned out maybe it didn't turn out to be so much the case, but would you help us in writing a test? And I agreed to. And so that's how I got involved in writing the first specialization test, which I would have sworn was 76, but Larry, if you say it was 75.
Take it. I'm with Larry. I got one of those certificates too.
Okay, well,
I don't know who forged them.
You took the first test then.
Yeah, I took the first test.
Well, is there anybody here who took the second test? I guess not. Well, the first test, as I recall, there may have been 200 some odd applicants or something, but
there'd only been about 100 people take the advanced course.
Yeah, I've forgotten. I think, what was it, 99?
Yeah, maybe it was 90. Right at
99 that passed that
test. And that was the genesis of the advanced course that we know and love, is specialization, which gave the opportunity to, or not the opportunity, but the need to have that kind of a test.
Very, very high failure rate on the first one too.
Oh yeah, it was.
You made it too hard.
Oh, it was nothing compared to the second test.
Not if you and Larry got by it.
Yeah.
Well, that's right.
It was nothing compared to the second test, because the second year when we did the test, John Nichols and I did the test the second year, and the test, we had understood that the test was to cover. These numbers are wrong, but let's say 16 hours over 2 full days. So we sent the test in to be approved by the Board of Legal Specialization. They sent it back and said that it was too long, that they wanted to do the test in like a day and a half, say, and that we needed to cut 2 hours out of the test. And so what we did is we went down and we just shortened the time on some of the questions in order to make it fit the Board of Legal Specialization's requirements. And we sent it back, and that was the test that they used for the second year.
What I remember about the first test was that it had about, it must have been at least 25% tax law. And just like it drove me crazy.
Yeah, well, there was
a lot of tax on that first.
Well, 5 years later, they were down to about 20% tax. It was.
Yeah, well, there was some different opinions about whether or not tax law was appropriate on the test, but I think they concluded correctly that if you're going to hold yourself out as a specialist, you better at least know what you don't know, and that was a good way of doing it.
Well, that's a bunch.
Yeah, right.
That's the only way I got out of law school, promise not to give any tax advice.
I took it in 1980, and they had us all in a room in this bar headquarters building before they took us into little rooms to take it, and they were giving us the instructions, and one of them was no calculators. And I turned to whoever was sitting next to me who I didn't know, and I said, "Do you mean there's going to be math on this stuff?"
That's why most of us became lawyers.
Yeah,
Right?
Because we couldn't
and they
be
did.
engineers.
They had this god-awful tax question that said maximize the tax benefits for both clients, and then they had all like a $6,000 used car and a $10 million this and all these different numbers. And I thought, well, now I know why they won't let us have the calculators. And I spent all my time figuring out how, if I got 0 points on this section and took the amount of time allotted to the rest of it, what did I need to get in order to have a chance? Never felt so bad in my life. The only thing that made me feel better, it was right before lunch. So at the lunch break, we all looked around at each other and we had the same hopeless, glazed look on our faces. And we literally found out about 8 years later that they had thrown that question out and graded the test without it. And until then, we were all, I had my certificate somewhere in my office, but I wouldn't tell anybody where because I wasn't going to give it back. But I knew it had to be a mistake.
One of the things that we were talking last night, and there's a story there I don't think any of you had heard. The first class that applied to take the specialization exam, of course, they had various objective requirements in terms of number of trials and so on and so forth, and they had peer review. And part of the peer review was to ask these other lawyers to rate you on all various types of things, including trial skills. And the Family Law Advisory Commission determined that if you had otherwise acceptable or appropriate credentials, but the average of your peers' ranking of your trial skills fell below a certain point, we actually put together a scripted mock trial and had several of the people travel to Austin where members of the State Bar staff and members of the Advisory Commission literally enacted a trial so as to.
I wasn't aware of that.
Yeah.
That's the first I've heard of that,
That's
too.
the first I'd heard of that.
It turned out to be far too expensive to try to implement once we realized that.
When was that?
The first year.
In
the first
75.
year?
Uh-huh. Yeah, I recall 3 or 4 separate lawyers that we had in the courtroom. Is there a city hall or
Travis County Courthouse is just down the road here.
Yeah, well, that may have been, it must have been, yeah. And we'd had courtroom and had opposing counsel and witnesses and a written script and the whole
I remember
thing.
on your application then you had to have lawyers you'd tried a case against and won, and also lawyers you'd tried a case against and lost. And that always disturbed me. I was hoping all those applications were burned after it was over.
Well, when I was on the Family Law Advisory Commission, I remember getting all kinds of applications from lawyers who had never tried a case to a jury.
Oh, yeah.
And
Well, you really get it now.
and you would
Boy.
try to find out, what the reason for this was and so forth. And about half of them would say, "Well, I always settle my cases," and
Larry,
we don't
when you
need.
and
And I kept thinking, if you can't try a case to a jury or you've never tried one,
how can you be a specialist?
yeah, how can you be a
Well,
family law
Well,
specialist?
not only that, it had to be within a given period of time.
Right.
Because I know I had to go tag on to another guy and get him to put me of record on an appeal because I had the requisite number, but they weren't within the time frame, whatever it was.
Mm-hmm.
So it changed a lot over the years. My understanding now is you can have one in lieu of the other. So many trials will forgive you your appeals or vice versa. My thought was then, though, that it all had to be in the area of family law. But now trial's trial.
Right.
They don't have to be family law.
Well, the original standard, the first year, had an objective number. You had
Yeah.
to have X number of trials. I've forgotten how many jury trials within the last 5 years, and so many appeals within the last 5 years. And there were very prominent lawyers who were very high profile in the family law area that did not qualify
Couldn't meet those
that
standards.
first year because of one or the other, and we met. We recognized that mistake, and the second year started putting some subjective things into it to allow for that. But that first year, there were people that we would all know the names of, very prominent lawyers who simply were not allowed to take the test.
Well, you know, I took and received my certificate in 1978, and by that time, the advanced family law course had been going on for, I guess, 5 years.
Depends on whether Larry's right or
Well,
I.
I do know that whenever the test
right.
was, I know that
know
the
it.
third course was the one in 1977 because that's the first one I went to.
Well,
I liked it so much I've never missed another one.
Well, I've never missed another one either, and I might have gone starting in 76, somewhere in there. But anyway, I can remember treating the course as if I were studying for the bar. I had only finished the bar in 73, so I was still close enough to that. And I remember taking those red books up to my hotel room in Houston, Texas, and studying and underlining every night, and then going back down to class in the morning. And of course, we didn't have the glitz and glamour that we have now in that course. It was a real serious study opportunity and we didn't have 1,000 people attending, maybe 500.
In 77, it came when you tried to sign up. They advised you that enrollment was limited to 250, and that preference was given to those who were going to take the specialization exam that year. And there weren't nearly that many. The entire thing was conducted in a classroom at St. Mary's Law School.
The first year when they had the University of Houston, wasn't it 100 people who attended it?
You know, I don't remember that, but I remember we had some of it on the first floor and some of it in the classroom. And
Well, they were running the
simultaneous.
advanced family law course, and back to back with that, they were running criminal law, criminal defense.
I remember Reba
right behind.
Razor and Don Smith were getting ready to take the test in 77, and I was sitting at a table at lunch. They were at the table, and Tommy won't mind if I mention Tom Raggio and I were sitting there. That was the foursome. Don and Reba are going back and forth. Now, the entirety of family law at that point consisted of the code, which was that thick, and the Eggemeyer opinion, which was brand new. And they were talking about stuff that sounded like nuclear physics, and I thought I must be the dumbest person on the planet. And the only thing that made me look better is I looked at my good friend Tom Raggio, and he had the same look on his face. And I thought, all right, I'm not alone. But
Joe,
God, they were brilliant people.
Joe,
And
prior to the code,
unbelievable.
prior to the code, it seems to me that we had two basic statutes. And it's been so long I can't remember.
4610.
4639A.
It was just two statutes, as far as I know, that was the entire body of law, of statutory law.
You had to fit everything within those
Yeah.
sections.
Yeah, and I remember they were about a page long. It was like a general jury charge. But it's phenomenal when you look at that, and now we've got law, you know. And
We may have gone overboard.
I think so. Well, now, you know, there are some sections of the code, those dealing with modification of custody, that have been amended, I believe I'm correct in this, every session. I think they've been amended every session.
Yeah, my favorite was the year they renumbered the entire family.
Oh, I love that.
Yeah.
Nobody
That
could find
blew
it.
my mind. I'm
No
still
matter
trying to
how
get it
well you
straight.
knew it. And people said, well, how bad can that be? I said, it's like they deliver your phone book on your front porch just like they do every year. and everything that's ever been in it is in it. The only change is it's no longer alphabetized.
And supposedly there were going to be no substantive changes.
Yeah.
I remember.
Yeah. Those famous last words.
Yeah, checks in the mail.
Well, Don, you were the principal grader of those exams for a number of years, weren't you?
Yeah.
Thank you, Don.
Yes.
Thank you, Tom.
Well, no, I'm mentioning this
God, I hate
because he did not become board certified himself until sometime later, correct?
He couldn't take the
He
exam.
couldn't grade himself.
Yeah, what happened is I graded it, wrote it and graded it for, I don't know, 3 or 4 years. And then we had I kind of retired from that, but we had a rule that you could repeat as much as 20% of an earlier test on a new test each year, and so
you had to wait 5
I had to wait
years.
5 more years before we had exhausted that 100%. So yeah, I took it in '84, and I want you to know I was scared.
You know, Tom,
Imagine how embarrassed I would have been if I had flunked it.
Well, you know, the test back then, when I was helping write it, we used to have quite a few essay-type questions. And then here, 10 years ago, they came down with the edict that, only 3 or 4
yeah, the law
essay
professors kind of got
type
involved
question.
and changed
And
it.
I remember the whole commission quit over it. And I stayed and one other, somebody else. Well, I can't remember now.
Yeah, that's when
It didn't.
I'd done my time by then with that. I told them I didn't have time to rewrite the whole thing, writing 25% of it.
Didn't they, the bar, whoever was doing it, didn't they hire some sort of Princeton
Oh, yeah,
testing
they-
service or
Yeah.
something?
Oh,
lot of-
yeah,
lot
and
of
he's the one that
educational.
came up with this idea. They were trying to standardize all the specialization exams, format-wise. But that's like when they
Because
hired
the practices are also
well,
standard.
that's like when the bar hired this guy that was going to straighten out the jurisdiction of all the courts, and he was going to, his idea was to have one court for the whole state, and all the other courts were subcourts of that court. And I was chairman of the family law section then, and Jack Sampson called me and said the guy wanted to talk to me, and my dad had been in the hospital. And anyway, I came down to see him, and I get to talking to him, and I says, well, I'm a family law lawyer, and we go, and I said, have you ever tried a family law case, a divorce? And the guy looks at me right now and he says, no, I got a niece that got one. And so I get to talking to him more, and I find out this man's never been in a damn courtroom in his life. He's some kind of an administrative law person that they paid something like $200,000 to conduct this study. And bottom line was, I was still messing with the legislature then, and I cut a deal with Texas trial lawyers to back them before the committee to do away with this unification statute they had, and in turn they compromised with me on 145 of the rules. I was also on the Supreme Court Advisory Commission then to keep cameras out of the courtroom and to lock up the records.
So that the uniform court system, I guess, is
It
what
went
you
by
call
the by. It was
that-
so ridiculous that
Was that something similar to?
it all came from the county judges who wanted to be district judges so they'd all be on the same retirement plan. That's where the whole thing came from.
Well, another
Kind
reason.
of like the uniform questions.
Another reason to
or
be involved with
pleadings.
the section and the foundation and all, because there's a very similar kind of legislation that's been bouncing around in the last few sessions where they're trying to say that well, this case is too complicated, so it needs to be reassigned to
Yeah,
some
different
special
track.
court. It's the Court Consolidation Act or
Yeah,
something like
yeah.
that, which is really an insidious, awful thing.
Oh,
But for everybody watching it constantly, it probably would have gotten a lot of traction. I wanted to mention, Don, you had your experience having to wait for the test, and there's a similar story about Tom Purdom. From our good friend in Lubbock who wrote and graded the thing with you, and had to wait like you did to take it. And the story is about him being on cross-examination in a trial, and some lawyer who is board certified is cross-examining him on his fees and starts to poke fun at the fact, well, you're not board certified, are you? And blah, 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 and leads him along. He said, well, why not? Well, because I've been writing and grading it for the last 5 years.
And one question too many.
That's right. Never ask that why question.
Well, I think all of us have participated in things like the exam commission and the council and the section and now the foundation, and those, we really didn't have anything but the section when I started out, and gosh, it's been such a great experience.
Oh,
making friends,
you bet.
making friends, learning more than I could have ever learned, thanks to people like all of you here. Law school was great, but it was nothing compared to the education I've had after.
That's the truth.
But I tell you, specialization was a real shot in the arm for family law, and I think generally across the board. But it really did more to upgrade the practice of family law than any other single thing, because people began to regard it as a real area of the law that you had to know something about, and that family law lawyers were real lawyers. They weren't just.
I've had lawyers from other specialties getting involved in family law cases, and they've almost unanimously come to me and said, I never realized how complicated and difficult family law is, because it involves all
It cuts across everything. Sure does.
areas.
I think we're about ready to wrap up here, and I just wanted to follow up on what you guys are talking about, because I've known everybody here for at least 30 years, and in your case for 40 years. And you still should have given me a higher grade.
I don't know, though, at this point that I can change it.
I don't resent it like I once did, but I haven't forgotten it. But if you can fix it, that would be nice. But I tell you what, this Joe created this family law system that we have, and all of these people have played an enormous part in tweaking it, and I won't say perfecting it, but improving it to what it is today. And whatever its flaws are now, it is so enormously different and better than what it once was, what it was in the beginning. And not because of what it's done for lawyers, although that's been significant, but what it's done for our clients, our consumers. You think about these things, the women who had literally no rights once they got married, and they had no expectation of insurance, and all of those things that were so commonplace back then. It was some sort of an indentured servitude that was there. They've changed the world in that regard, and all of these folks have had a huge part in that. And the greatest thing about getting involved in the family law business in terms of the section and the foundation and TBLS and anything you can volunteer for is that you end up, when you look back after all these years and you've got friends like this, and we have had the best time doing this, we've enjoyed doing this, and thanks to Kathy Kinzer for asking us to do this. And I think most of us got through without embarrassing ourselves too horribly. So now we're going to stop before we mess up. But thank you all. It's been a great pleasure.
One too many questions.
Before we ask one too many questions.
Ready,
Right.
set, stop.
Thank you very much.